morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime. This is where we cover some of the most interesting live trials in the country today. And today we have a big trial to cover. And we're also going to talk about two other trials that hopefully we'll be covering today as well. But we have to start from where we left off yesterday. That is right. We're in verdict watch right now in the Tex McIver case out of Atlanta. Now, anybody who's been following this case knows where we are, and anybody who's just joining us, first of all, welcome. But here's what really is happening. This is a case about a prominent local attorney who is on trial for shooting and killing his wife, Diane McIver. Now, the state will say that he did this for financial gain, that he had a lot more to gain from her being dead than her from being alive. Now, the defense is saying that this was all a tragic accident. Remember, he shot her from the back seat of a moving car. She was in the front passenger seat. He was in the back seat. Their friend was driving. He said the gun went off by accident. He was holding the gun, fell asleep. It went off by accident. But what you heard yesterday, after a long trial, this went on for weeks, ladies and gentlemen. We were covering it every day. We heard the closing arguments by both the defense and the state, and it was incredible to watch. It was incredible to watch both of these sides formulate their arguments into what they thought was the best reason for why Mr. McIver was guilty or why Mr. McIver is not guilty. Now, here's what should be noted. McIver faces 5 separate counts, and that includes a murder charge as well as an influencing witness charge. That's right. The state believes that Mr. McIver tried to influence Danny Jo Carter, who is the driver of the car. She was the main witness in this case. Now, here's what I want to let you know. In terms of the murder charge, what we learned is that Mr. McIver could be found guilty by the jury for murder, or he could be found guilty of something less. Involuntary manslaughter, or he could be found not guilty. Now, we have a poll up. If you go to Law and Crime on our Twitter feed, there's a poll to determine what do you think the jury will come back with, because they're continuing their deliberations today. I'm looking at the seal right now in the courtroom. We are waiting for them to come back today and begin their deliberations. They deliberated for about an hour and a half yesterday. Now, we don't know if they will have a verdict today, but they might. Some people are saying that they might have a verdict later on in the week, maybe before Friday, maybe even on Friday. We are going to be here all day, and as soon as there is an update in the courtroom, we're going to make sure to go to it, and we have so much to talk about in this case. So do not turn away. We have to talk a lot about McIver. But before we go to McIver, I want to preview another case that we might be streaming later on today as well. This is a case, this is a case out of Florida. It's the case of Brian Hyde, and it started yesterday, and hopefully we might be able to stream it for you later today. And we're going to show you some photos of the victims and the defendant in this case. Brian Hyde is on trial for viciously stabbing and killing a few different people. First, 19-year-old Michael Kelly, his girlfriend, 17-year-old Starlet Pitts, and also Starlet's mother, Dorla Pitts, who was 37 years old. But the story doesn't end there, ladies and gentlemen. Sadly, Starlet, who was killed, this horrific attack resulted in the death of her unborn child, Ari Kelly. Now, that's not also the saddest part about this. A 1-year-old baby was found in the home in this horrific crime scene. Now, thankfully, this baby was uninjured. Now, Hyde was originally brought into attention because he was discovered by police after driving Dorla Pitts' white Range Rover. Remember, Dorla Pitts is one of the victims here. Now, the defense is saying that law enforcement did a sloppy job on this case, and they didn't account for evidence of an alternative suspect. So this back and forth between the state and the defense, hopefully we'll be able to cover it for you later today. Again, the trial started yesterday, and we will hopefully be able to continue showing that for you today here on Law and Crime. But that's not the only case I want to preview for you. As you know, we have also been covering on our dedicated feed on lawandcrime.com the David Copperfield case. Not a criminal case, a civil case, where David Copperfield, the MGM Grand, they're being sued by Gavin Cox. Gavin Cox was a participant, an audience member in one of David Copperfield's magic tricks, the Lucky 13 magic trick, and he got injured during the course of this trick. We have a short recap, a preview of this case. Take a look, and we'll talk more about it.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist, who once cooked for British royalty, claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during a disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
So everybody, we might be covering that later today on lawandcrime.com, and then maybe we'll cover it here on the network as well. We expect a live feed later on, maybe 12 p.m. Eastern Standard Time. Again, it's a case out of Las Vegas. Funny enough, I've been to that show, and I've seen that trick. And that's really an important part for the defense, because they said that they have tested this trick. They've had 100,000 people over the last 15 years participate in this trick. And Mr. Cox is the first person who got injured. We'll talk about more of that case later on today. But let's now focus back on the Tex McIver case. That's what our main issue, our main talking point is for today. There's so much to talk about, including what the jury is deliberating about, what they asked for yesterday. Now, again, I talked about this Twitter poll that we have. This is how you, the viewers, have split between what will happen to Tex McIver. If you see that, that's the latest poll right there. 28% of you think that he will be found guilty. Can we put that feed back up? I want to just make sure I can show it right there. That was 28% of the people are found guilty, think he's going to be found guilty of murder, over 35% guilty of involuntary manslaughter, and 37% not guilty. Now, ladies and gentlemen, I don't know about you, but that seems pretty split. And that's the difficult part for the jury, and that's why we think they're going to be deliberating for such a long time. Now, yesterday, we saw the closing arguments by the defense. We saw the closing arguments by the prosecution. I talked about it. But what I want to do for you right now as we wait for the live feed in the courtroom is to play some of those, and we're actually going to play all of it, the defense's closing arguments. That's where we're going to start. Because Don Samuel, one of the attorneys for Tex McIver, delivered a remarkable, I don't use that word lightly, a remarkable closing argument. Take a look. That's Don Samuel delivering the closing argument in the Claude Tex McIver case. Now, we are covering this case. I'm looking at the courtroom feed, waiting for it to begin again, waiting for the jury to begin their deliberations. And as soon as we have an update, we'll make sure to go into the courtroom. But let's dissect a little bit about the closing arguments from yesterday, because there is a lot to talk about from the closing arguments from yesterday. So I want to bring in my very special guest for this morning, law and crime trial analyst Jonna Spilbor. Jonna, great to see you.
Good morning. Good to see you as always.
Now, Don Samuel, I thought, did a terrific job of saying, look, there are 16 elements of reasonable doubt here, and really you only need one. Right. And what we kind of heard at the beginning was, and we've talked about this so much, there was nothing unusual in the events leading up to the shooting.
No.
And if you're going to kill your wife,
right,
are you going to do it like this?
With a witness driving the car? It seems so implausible. And that really is one of the items that the jurors can consider in deciding whether this was an intentional murder, which is what the prosecution wants them to find, or a terrible accident, which is what the defense wants them to find.
Well, let's talk a little bit about the latest developments right now. So we know the jury deliberated for an hour and a half. Deliberations will resume today. They've asked to have the gun unlocked so they could test pull the trigger. Now, we know they also examined the SUV. They weren't allowed to sit in Diane McIver's seat, but they sat in Tex McIver's seat. Mm-hmm. They also asked for 11 more copies of a jury instruction so everyone could have one. Based upon these requests about the gun and the jury instructions, what do you see that they might be thinking about?
Well, first, I want to know which jury instruction they wanted everybody to have a copy. I mean, all of them or one of them in particular? I don't know if we know that. But before that, I have a very large issue and bone to pick with the fact that the jurors should not be testing the weapon. And I wouldn't say that in just every case. But here, I think one of the facts that was established on both sides is that nobody knows how much pressure it took to pull that trigger at the time the trigger was pulled, right? All we know is this: guns don't go off unless the trigger's pulled, right? The trigger had to have been pulled. But we don't know whether it required 4 pounds of pressure, 8 pounds of pressure. We don't know. That was established. So for the jurors to sit there and play with the actual gun and determine, you know, was it easy, was it this easy, or was it this hard, when they don't know how much pressure Tex McIver had to use, to me, gives them license to draw conclusions that are unsupported by the evidence, because the evidence flat out says we don't know.
Well, this prosecution, in their first part of their closing argument, said or I don't even think they want to say concede, but they acknowledge the fact that the gun was cocked. Now, if it's cocked, again, it's placing it in a limited position about how they could argue what would happen to this gun. And as Bruce Harvey said, we don't know if it was in single action. We don't know if it was in double action.
Right.
And I think that fact alone could be reasonable doubt. Now, I do want to let you know the entire jury charge and instructions were provided to the jurors.
Okay.
They really want to understand this law. They really want to understand, is it going to be murder? Is it going to be involuntary manslaughter, or is it going to be an accident? Now, in a little bit, I'm going to play Don Samuel talking about what the difference is between involuntary manslaughter and an accident. But, okay, you're a great attorney. How do you think the jury should be thinking about the murder charge versus involuntary manslaughter and accident?
I think out of the gate, if I were the foreman in that jury box, I think they can make short work out of the murder charge, only because, look, they have heard the evidence. Aside from the week-long break that they had where they could rest their brains, Jesse, if they came to a murder conclusion, I would be so surprised. The motive just wasn't proven by the state. So many other factors that just seem to defy common sense, like what you just said. You're going to kill your wife in the backseat of a car with your neighbor and good friend drive. Like, it just does. After a nice dinner, it doesn't make sense.
But to play devil's advocate, we cannot forget, and this is very important, we cannot forget that he shot and killed her. So it's not like a situation where who done it. We know he shot and killed her, and I'm sure jurors are going to wrestle with that.
We know he shot and killed her. What the jurors have to wrestle with is the why, more so than the how. If he intentionally shot and killed her, they're going to find him guilty of murder. Frankly, don't think the state made their case there. Next, if they agree with me, they have to move on to, was this an involuntary manslaughter situation, which, and we've talked about this on the air, they might find him guilty of that, because is it reckless? Is there a reckless disregard for human life when you're in close proximity in the backseat of a car, you're sleeping, you've got your gun cocked, if that was established
well,
by
actually,
the evidence?
let me just go back. I actually misspoke. Prosecutor Convery, who was the first person to deliver, she said the hammer was not cocked. But again, it's a question, is that a fact in a case? Has that actually been established where no one knows for sure?
No one knows for sure. So cocked, not cocked. The point is, you're in the backseat of a car in close proximity to two other people. And, you know, his version is, we went over a bump. His finger had to be on the trigger. Here's what gets me, because I'm a gun owner. You do not put your finger on the trigger till you are ready to shoot. You learn that in every gun safety class. He was not a novice at this. So the fact that he had to have had his finger on the trigger is reckless to me.
You're going like this when we know, based upon the crime scene analyst brought up by the defense, that it was positioned like this on his lap. So, and that really is an issue. This or this is really important.
You can still have your finger on the trigger, whether it's this or this.
All right. So here, we're debating it back and forth. We know you guys out there are debating.
The jury's going to be too.
The jury's going to be deliberating it, and you guys have been talking so much about it. Again, if we have a Twitter feed on Law and Crime on our Twitter page, you can go there, vote about which way you think this case will go. And people are split. People are split right now. What I want to continue playing for you is the defense's closing argument. Again, Don Samuel delivering a terrific job, not just poking holes in the prosecution's case, but also criticizing the prosecution for many of the red herrings that he alleged was thrown out there. So we're going to tackle that as well and talk about it a little bit more. So here's a continuation of Don Samuel's closing argument. Welcome back, ladies and gentlemen. We are in verdict watch in the Claude Tex McIver case. That's right. The jury began deliberating yesterday in this case after the conclusion of the closing arguments by both the state and the defense. I'm looking at the feed. As soon as the jury comes back to begin their deliberations, we'll make sure to go to the courtroom. But we're continuing to keep a very, very close eye on this case, because we don't know which way it's going to go. Now, you hear Don Samuels in the defense's closing arguments laying into the reasonable doubt, and from an outside perspective, there really is some strong reasonable doubt. Again, I'm here with Law&Crime trial analyst Jonna Spilbor. Johnny, you heard him. He's talking about how if you're going to murder someone, you're going to murder your wife. They live in a ranch away from everybody. Could have killed her there, even though we don't even like to think about this.
No.
But I thought this was an interesting tidbit that I didn't think about. Danny Joe Carter was best friends, or became best friends again, I should say, with Diane McIver. If you're going to kill your wife, are you really not only going to have a witness, but her best friend who has no incentive to side with you whatsoever?
Right. That's one of his 16 points of doubt. First of all, can I just say this? I love the fact that this defense attorney is actually, instead of saying reasonable doubt, you just have to find reasonable doubt, he's laying it out for I'm giving you 16 opportunities.
That's a great strategy,
it is
right?
Brilliant,
right.
if you ask me. But second, if you remember way back to Danny Joe Carter's testimony, she impressed me for a couple of reasons. Number one, she was very even. You know, some witnesses will take the stand and they have an axe to grind, they have a side to take, they have a slant. Her best friend is dead, died in her car with her next to her, 6 inches away at the wheel. She was very even and she had a lot of credibility. Her affect gave her a lot of credibility. And she could have been like, that SOB killed my best friend. She wasn't like that. I think she didn't hurt the defense, and I'm not so sure she helped the prosecution. Yeah, no, she was a good witness. She was a good witness down the line. But I gotta say, I love when the defense really says, are you going to say, prosecution, that Tex McIver is such a devious mastermind that he is going to kill her in a way that wouldn't look like a murder, and hold his hand down on the side, on his lap, and fire it because he knows that when investigators come, oh, he didn't hold it upright, you know? And then I love this part. This part was one of my favorites. And Don Samuel had a big issue with it. The hospital, okay? He's so devious. I'm going to tell Danny Joe Carter, go to Emory Hospital, where I know they don't treat gunshot wounds. I know this, because if I take her there, she won't be saved. I thought that was one of the weaker parts of the prosecution's case. But what did you make of the hospital issue? One of the many weaker parts of the prosecution's case. You get the sense at this point that the prosecution is really stretching. They're not trying to fit a square peg in a round hole anymore. They're actually having to stretch this round peg to get it into the round hole on the murder charge, and I really feel the jury is going to see that. What is going to hurt Tex McIver, though, that we haven't talked about yet during this part is, you know, he did kind of not change his story, but the fact that, you know, he might have wanted a witness or two not to say something, which when we were covering that part during the actual trial, I could see where his mind was. I mean, he's an attorney. It was a frightening thing. His wife is dead or dying. You know, to want to not manipulate the evidence, that's too strong a word, but to not want to bring forth the more damaging things, I could almost see as human nature. Almost. But I don't know if the juries are going to agree with me on that. Well, later on, you're going to hear Don Samuel say, look, he's an attorney. First thing you do when you get in trouble is call an attorney. You know, it wasn't like he called his attorney in the car while she was dying. Called the attorney once, you know, was at the hospital. I mean, let's not forget, he knows he shot her. I mean, he knows he shot her. So I hear that. Again, his problem, and I'm not saying he's not going to be found not guilty of anything, let alone that influencing a witness charge. And we'll talk about that a little bit. But I do want to get into the last part of what he just talked about here, was the comparison between the sleep experts. So the defense had a sleep expert, the state had a sleep expert. Now, the defense sleep expert said Mr. McIver suffers from a sleep disorder. The state was saying that may be true, but he didn't fall back asleep. If he knew there was a danger, he said the hairs on the back of his neck stood up. And if that's really the truth, then how could he fall back asleep? Now, I thought this was a brilliant move. I think we might have been talking about this. Do you actually mean the hairs are stood up on the back on your neck literally? He's like, it's an expression. It's what people say. But is the jury going to see that differently and say, wait a minute, I believe the state's expert here, because if he really was that fearful, how do you fall back asleep? Let's talk brass tacks for a minute. Please, let's do that. How old is Tex McIver? He's an older man. He's 75. 75. He's 75. What time was it? It was late at night, 10 o'clock. Where were they coming from? A big dinner? And they were playing golf earlier that day. They were playing golf all day. Listen, I'm not 75. I'm in the back seat of a car. I'm falling asleep 10 o'clock at night after a big dinner and a day of golf. I mean, listen, whether he was stressed or not stressed, 75-year-old people fall asleep in the back of cars. Listen, just happens.
I'm 70 years old. I age
you remarkably
extremely
well.
gracefully.
Yes.
And I've fallen asleep in the back seat of a car.
In the front seat of a car, as long as you're not driving. Right? The car is kind of what people do when they have children that are a little, ornery. They put them in the car.
He did. Here's what I thought was very interesting is the fact that. Yes, but there's a difference between deep sleep, REM sleep, and the idea if you wake up like that's something to consider, no? I mean, if you're in such a deep state and then you wake up and you're startled, it would make more sense for the defense's case, but he couldn't have fallen asleep, biologically couldn't have fallen asleep into that deep state within 7 or 11 minutes.
All right, so let me ask you this. As a human being, forget being lawyers for a minute, have you ever... when you're laying in bed at night, you're just about to fall asleep, you kind of go into a dream state, and then the next thing you know, you're startled and you wake up. Like your dream doesn't quite begin and you wake up. Has that ever happened to you?
But then again, I'll counter that. How do I know I'm in deep sleep or not? I'm not looking at the watch. I don't know. I know what I'm feeling. I don't know biologically what's actually happening to me. And I could be asleep for 5 minutes in my mind. didn't I just fall asleep? But I was really asleep for a while.
The fact that you can be startled awake, and we don't have to know exactly what level the brain waves, Tex McIver's brain waves were in. Think about this. Whenever you have experts competing with each other in any trial, civil, criminal, or what have you, you're going to have an expert over here who's been highly paid to give an opinion that's going to contradict the other expert over here who's been highly paid to give an opinion. And I don't think this case is going to turn on how deep Tex McIver's sleep was. I don't even think it's going to turn on whether he really has that sleep disorder.
Well, we'll have to see. We'll have to see what the jury ultimately comes back with. Again, we're in verdict watch on the Claude Tex McIver case. An attorney who is on trial for murdering his wife, Diane McIver, and he also faces another count of influencing a witness, Danny Joe Carter, the driver of the car, the crime scene in question. I want to continue playing for you the defense's closing argument. This is Don Samuel delivering all of the reasonable doubt in this case. Take a look. Don Samuel making some really good points in the closing argument in the Claude Tex McIver case, a case that we're following very closely, a case that's in verdict watch right now, a case that I see right now on our live feed and waiting for it to start. Again, the jury might be brought in today. We might see a verdict. Who knows? Who knows? We might see a verdict later on this week. We are carefully monitoring this case, and as soon as there's an update, we'll make sure to go to it. And again, go to our Twitter page because there's a poll up about you can choose what you think will ultimately happen with Tex McIver. Will the jury find him guilty of murder, involuntary manslaughter, not guilty? And let's not forget, there could be a possibility of a hung jury. Let's talk a little bit more about it with law and crime trial analyst Jonna Spilbor. You think there might be a hung jury?
You know, with so much to chew on here, that is a possibility. I mean, it's always a possibility, but there's a lot of dots to connect in order for them to all agree on what, if anything, they're going to find him guilty of. So, yeah, I suppose there could be a hung jury.
Unfortunate, because we would have to start the whole process over again.
I would bet you $5 right now, there's no way there would be a retrial if there's a hung jury. Not for a 75-year-old defendant with the state's got to know that their evidence is not all that.
Let me ask you this then. Could they come back and charge him less with what he was originally charged with, involuntary manslaughter with reckless conduct? Could they come back and say, you know what, we are going to retry him, but lesser charges, find a jury that doesn't know about this case or very little about this case, and there you go.
You know, that's a really good question because double jeopardy probably wouldn't kick in, but if there were a statute of limitations on the lesser offense that may have already run, that could prevent that from happening. But do you really think, given the nature, I mean, I don't know if the state really thinks that it's got a solid case, but given the age of this defendant and the time, look, this was how many weeks? Forget the week-long vacation. 4-week trial?
It was a long time.
Trial. That's a lot of time and money.
27 days.
It's a lot of time and money. Based on these facts, I just don't see that happening. And can I say something else? I just love, we had talked about this during the trial too. I love that the defense attorney is arguing, if you're going to kill your wife, are you going to ask her to hand you the murder weapon? Remember we talked about that because that is indeed what happened. And that's another one of his 16 points that the jurors are going to have to chew on.
I'm going to flip this, okay? I'm going to flip it again. Here's what I could say to that.
Devil's advocate? You're gonna
I like to play devil's advocate here. Did Diane McIver have any idea that Tex was going to kill her? So she handed him the gun thinking, I'm going to hand my husband the gun. I don't think he's going to shoot and kill me. Another way to think about it. She said it was an accident, right? She said it was an accident to the doctors. She didn't see the gunshot. She didn't see it fired. She didn't know what was happening behind her. How did she know it was an accident? Maybe she honestly believed that this was an accident. Doesn't mean it was an accident.
Both of those circumstances would most likely lend a jury to infer that she and her husband had the kind of good relationship that the defense is telling the jury that they had. Because look, if you have a crappy relationship and you think your husband is going to kill you, that's probably going to manifest in a number of ways, not the least of which, her best friend, forget the day of the murder, somebody would have to know that, oh, she was having problems with Tex and Tex was threatening her. We didn't hear anything about that. Plus, look, they just came from, as the defense attorney said, pretty much a pretty fun day.
Yeah.
Like there was just nothing there. If somebody wants to kill you, the last thing you're going to do is hand them a gun when they're sitting behind you.
Yeah.
So I think the jury can infer from that. The defense point is there was nothing wrong with this relationship.
I mean, golf, steak, sounded like a wonderful day. Here's what I have a question. They talk about that Publix bag. We know that the gun was in a bag.
Right.
Now, it became an issue because Danny Joe Carter, who knew that there was a gun in the car, never saw it in a Publix bag before. We know from earlier testimony that he kept it in there because he was afraid of it getting stolen. The Publix bag became such an issue, but as you heard the defense say countless times, what does it matter if the state is going to say that he kept it in that bag to contain the GSR from spreading? It's not like he was trying to hide he was the shooter. Everybody knows that he was the shooter.
Right.
But couldn't you say that? Yeah, I can't even say, well, maybe he was going to eventually shoot her at a different time and place and wanted to hide it. No, he shot her in the car. I mean, what side are we supposed to believe? That he wanted to shoot her then? He didn't mean to shoot her then? What does it matter, the bag? What do you think about this Publix bag?
I think the bag doesn't matter. My theory about the bag is that you put any item, a gun, it could be anything, booze, you could be anything. You put it in a bag because you don't want people outside the vehicle to see it. So if he put this weapon in a bag and put it in the glove compartment, it was because he didn't want it to be readily seen if for some reason the glove compartment had to get opened, or somebody did break into the car. They might, but that's the only reason why he didn't do it to hide evidence of a crime. I think it was just a matter of convenience to hide the fact that there's a gun in a car.
Yep. All right, let's see a little bit more of Don Samuel's closing arguments. And again, we are on verdict watch. We are carefully monitoring the courtroom. As soon as there's a feed, we'll make sure to go to it. But what I want to play for you right now is a continuation of Don Samuel's closing argument. All right, everybody. So that, again, is Don Samuel delivering the closing argument in the Claude Tex McIver case out of Atlanta, Georgia. We are keeping a very careful eye on the courtroom because we are on verdict watch. That's right. We're waiting for the jury to come back with a verdict in this case. What will they find for Mr. McIver? Will they find him guilty across the board? Will they find him guilty of some things and not other things? And really, let's break down, will they find him guilty, be found guilty of murder, involuntary manslaughter, or not guilty? So again, I'm here with Jonna Spilbor. Now, we talked so much about the murder and all this. Let's say they say, you know what, state, you haven't proven murder.
Right.
But there's a really strong argument that this is involuntary manslaughter because we know involuntary manslaughter to be a reckless act. Now, here's what I don't understand. If you look up the statute of involuntary manslaughter, I don't know if that completely vibes with the description presented by Don Samuel about you have to just demonstrate an intentional disregard for a known unjustifiable risk, because I thought intent was not an element of this. Am I confused?
No, you're not confused, and I agree with you. The definition under the Georgia statute does not vibe with what the defense attorney is trying to tell the jury they should also find. And this is the one thing where I really disagree with him. He runs the risk, stop using the word intent, because the whole point is the state is trying to prove that Tex McIver intentionally killed his wife. And if you start trying to explain that reckless conduct also requires intent to be reckless, which I think is convoluted and not true and not correct, you could also confuse the jury and not to your favor.
Well, again, maybe we're not Atlanta attorneys. We're not prominent in that area. Maybe they've decided. Maybe there's been a change in the law. Maybe their jury instructions were a bit different. But what I am confused about, even if we take that as true, how do you distinguish then an accident? What would make this an accident in the sense that if he took his gun out, he knows there's a danger, he takes it out in the car, he has it on his lap, and he falls asleep, I would assume the falling asleep is really the intervening cause here. So, in other words, if he was awake, alert, and someone hit into the car and it went off, that's an accident. There's no way he could have avoided that.
Good analogy,
But him falling asleep was his own fault, right? Really, the question is, whose fault is it? If he fell asleep, it's his fault, right?
Yes, but I think the argument is falling asleep is not the reckless act. The reckless act is, if you're going to argue it, would be the combination of having a gun on your lap with your finger on the trigger. That's the biggest sticking point for me. And falling asleep with your finger on the trigger, because then you run the risk of hitting a bump, perhaps waking up startled, and she's dead.
Do you think it was a weak argument by Don Samuel to say it's not illegal to have a gun in the car on your lap? That's not against the law.
No.
But then again, if you think about it, none of the behavior before a killing is technically illegal, but it does add into, you have to have it, right? So in other words, if I'm carrying around, I don't even know if I'm carrying around a gun, okay, I'm allowed to carry it around, but I keep it in my pocket where there's things in the pocket that could pull it off. It's not illegal for me to do that, but you're definitely creating a dangerous situation. It's probably going to be against the law. Well,
and that's the point. You can create a dangerous situation, and it's not illegal. And again, those are the facts. Those facts leading up are facts that the jury is going to have to contend with to determine whether this was a flat-out accident, meaning not guilty of anything, or whether there was reckless conduct which would allow them to come fairly easily to an involuntary manslaughter.
See, I think if they charged him initially with involuntary manslaughter and that was the trial, it might have been a more open and shut case. But when you've already flavored it as a murder trial, and if you can't find murder, then find intentional and find involuntary manslaughter, doesn't that change the way jurors think about it?
I don't know if it's going to change the way they think about it. It's going to give them another option that in a perfect world they wouldn't have had because, like we had talked about during the trial, the prosecution did not waver. They picked a lane, and that lane was he had motive. He had financial motive. He wanted to kill her. He set out to kill her. He premeditated, and he killed her.
Yeah.
And they didn't even consider the fact that this really was an accident, was a reckless act resulting in death. And not for nothing, in the real world, in a practical case, if they had only charged him with the involuntary manslaughter and never wavered and never elevated the charges, we might not have had a trial.
Yeah.
The punishment for an involuntary manslaughter, apparently they can punish it as a misdemeanor in Georgia. That's a pretty light sentence. This man has been sitting in jail for quite a while. So if they came back with an involuntary manslaughter verdict, it's quite possible that he's going to walk out of jail anyway because he's been sitting in there so long, I'm assuming getting credit against any time that he may serve in the future.
It's an interesting perspective. It's possible the misdemeanor charge was dropped and it's just now the felony, but even if that's the case, you do make a point that it is for time served, how long he's been in jail for. There was another interesting tidbit in Don Samuel's recap for the jury about the influencing witness charge, which we don't talk about as much as the murder charge, but it's a serious charge nonetheless. Why would he want to quiet up Danny Jo Carter? Why would he not want her to speak to the police when she's saying it's an accident? That's a good point.
Yeah, that is a really good point. But it goes back to something else that we had talked about, and that is he really is a lawyer. And when you're a lawyer 24/7. And he's a lawyer who just let's give him the benefit of the doubt for this argument, he just accidentally killed his wife.
Yeah.
So, we can't really say, God forbid, I hope we never know what that actually feels like.
Right.
But, when you're a lawyer, you're a lawyer. And I'm sure that he was in some sort of panic, yet he was in a lawyer panic. And that's why he was saying things that he probably, in the light of day, wouldn't have said.
But then again, there is a strong argument that he knew the police were there. They knew they were going to talk to Danny Joe Carter, and telling a witness, the prime witness, not to get involved, it may be hard for the jurors to separate that from a situation where he's innocent.
You know, and if they come back with a guilty verdict on that and they don't convict him of murder, involuntary manslaughter, he's still doing a jig, because he's going to, like I said, I don't know what the exposure is for that count, but he's been in jail for a pretty long time.
Interesting, interesting. Well, we'll have to see which way it goes. Again, we're on verdict watch, carefully watching. Now, again, I think the jurors have now been in deliberation for over 2.5 hours. Not surprising. We think it's going to take them a while to deliberate this, because the facts really can go all different ways. And we know, I keep saying, if you go on Twitter, onto Law&Crime, our page, you can take a poll, you can go on our quiz, try to determine what you think will happen to Mr. McIver. And the last time we checked, it was pretty split between murder, involuntary manslaughter, or not guilty. And if you guys out there are having a tough time making a decision, you can imagine what will ultimately happen in this jury room when some jurors are trying to convince other jurors about their point of view. To be a fly in the wall right there. All right, guys, here's what we're going to do. We are going to continue playing for you the closing argument from Don Samuel, because it really is a great closing argument. So here's a continuation, and we're going to play all the closing arguments for you in the rest of the day. So again, here is Don Samuel. All right, everybody, we're watching some of the defense's closing arguments there, and really interesting to watch Don Samuel, who was such a pit bull throughout this case when he was doing cross-examinations of key witnesses, speaking to the jury in a very calm, measured, almost friendly tone, really relatable. We'll talk about that in a minute. Again, we're keeping a very careful eye on the courtroom. We're in verdict watch in the Tex McIver case. As soon as we have an update, we'll make sure to go to it. Again, I'm here with Jonna Spilbor. Would you agree with me that his tone, I enjoy his tone during these closing arguments. I think that it's very relatable, making, like, I'm one of you. Does this make sense to you, what the state's doing? Exactly.
And it's a great tactic, for lack of a better word, if you want the jury to employ its common sense. Like, he's almost not a lawyer right now. He's just sort of explaining it as you would explain it to somebody who just didn't know, and he's explaining it like that, and he's making some really valid points. I mean, he does have to sort of parse out some of the technicalities. Like, I was very interested myself when he just said to the jury words to the effect of, it's not a crime to tell somebody to lie. Right. So if you look at the influencing witness charge, if you actually look at the statute and break it down about what actually applies to Mr. McIver, you would say that he tried to mislead Danny Joe Carter into telling the police something. Right. But is he right? Is that the way to think about the law there? It's not a crime to tell someone to lie? I think it's, you know, it's like taking an X-Acto knife to the elements of that offense, but he's got to go there. Let's put it that way. You know, if he has a shot at the jury coming back with a not guilty verdict all the way around. Right. He also talked about something interesting about how there were red herrings, and he'll get into it right now about how they're really hitting on the prosecution, how they threw all these little things. But that's sometimes effective, no? Isn't that sometimes effective for the state building up a larger narrative about a relationship between two people? It's only effective if the other side can't detract from it. It's only effective if the other side can't say, wait a minute, that's a red herring. That isn't exactly what it appeared to be. And the defense did a good job of that. Is it a red herring to have witnesses testify to the fact, which he just said? Tex McIver looked angry in the days before the shooting, and you know what? Diane McIver, she looked distraught. Does it matter? I think it is a red herring. I mean, think about your last week. How many times were you happy? How many times were you upset about something? How many times were you stuck in traffic and cursing on your steering wheel? Like, that's just life. In order to connect the dot, I mean, that's what the prosecution really can't do. Can't say Tex McIver looked angry and therefore he killed his wife, or Diane looked I don't know, distraught, and therefore there was no dot connection there, because there were so many other plausible explanations that it could easily turn the other way. In other words, if we could, that would have been more relevant than if throughout the rest of the weekend there was a problem between them, right? Or even that day. I mean, you can't. So a week ago, somebody looks distraught, somebody testified that he came to the office and he was red-faced. And red-faced, why? Red-faced because he was having an allergy attack? Red-faced because he was so furious that he was red-faced? Or red-faced for some other reason? I mean, you can't, there was no dot connection there. The prosecution wants the jury to infer that a red-faced Tex McIver a week before must mean that a week later he killed her in the backseat of a car with her best friend driving.
And it hurts their case.
Too big a leap.
It doesn't hurt their case, too, because there's no one testified that they had a bad relationship or that they were abusive. Sure, she teased him a little bit. But, I mean, it's a normal relationship. But, again, if it was more like they had an abusive relationship, they were constantly yelling at each other, that would have fit more into the narrative. Or if you said, look, in the moments before the shooting, look, there's some testimony about that she was teasing him about his weight, and she said, Tex, wake up, wake up. But, again, you're not buying it.
No, not buying it at all, and I'm not so sure the jury is going to buy it either. There really was no, and no pun intended, no smoking gun here. There's nothing that the jury is going to be able to point to and say, aha, this is the reason why Tex McIver wanted to kill his wife and then eventually killed his wife. Even all of that convoluted financial information with the loans and the foreclosure on the rent and all that stuff that I think was done for tax purposes, not incentive for him to want to kill his wife.
Let's break that down. It does get very complicated when you talk about the will, the ranch, his deteriorating financial situation, her financial situation. You're saying that they're looking at it in the wrong way, the prosecution?
Yes. I think there are a couple of angles you could come at that financial information from. When you're trying to prove that a man killed his wife, you're going to look at it and say, he had a financial motive to kill her because she could have foreclosed on the ranch, and he owed her however many hundreds of thousands of dollars in, quote, loans. But I think that's a really weak argument when you consider that a lot of that stuff can benefit you on your tax returns, and there was no evidence whatsoever that Tex McIver was going to be homeless any day now, which, okay, maybe that would have given him motive, but he probably would have been better off, if that were the case, if there were a financial motive, he might have been better off divorcing her, not killing her.
You would imagine what would have happened if she wasn't working or she was making less money than Tex and he was in the better position. You could say, well, she was a drain on his finances. You can imagine that.
Right.
John, a question. We're looking at the courtroom feed. Nothing's happening right now. We are waiting for the jury to come back with a verdict. It could happen today. It could happen tomorrow. Who knows? What is going through the minds? What happens to an attorney when they wait for a verdict?
A couple of things. Number one, when you invest so much time and energy in a case, and I guarantee you, with every fiber of the defense attorney's being, he believes that his client is innocent. Yeah. Just like probably a lot of people watching believe that Tex McIver is innocent. But he's lived and breathed it for a long time, not just the trial, because a lot happens before you get to this point. So he's going to be understandably nervous. But at the same time, again, as a practical matter, he's got other cases and clients and stuff that he's got to handle too. Right. So you're kind of like managing that while you're cajoling or consoling your client and waiting for the jury to do the right thing. And you constantly second guess everything you said, from the opening statement to the moment you sat down after your closing argument. You second guess it all.
And guess what, Jonna? They can rewatch it here on lawandcrime.com. We're covering all of their closing arguments. And so, again, we're just analyzing it. Hopefully we're not too critical of either side. We're just analyzing it down the middle. So what we're going to continue doing as we wait for the verdict today, we are continuing to play for you the defense, and then we will play for you the prosecution's closing arguments. So here again is Don Samuel from yesterday. Welcome back, everybody. We're covering the Claude Tex McIver case here on Law and Crime. I'm looking at a live feed in the courtroom, waiting for there to be an update. That's right. We are waiting. We are on verdict watch, patiently waiting for the jury to deliberate. That's what they're doing right now. They're deliberating. We're waiting for them to come back with a verdict. It may be today, it may be tomorrow, maybe later in the week, maybe next week. But that's okay, because we want them to deliberate and really, really think about each one of the facts. That's a live feed into the courtroom. As you can see, not much going on, pretty slow compared to yesterday when the courtroom was packed with those closing statements that we saw. Let's talk about a little bit more with Jonna Spilbor. John, it's so good to have you here. I'm happy you're here to talk about all these different facts of the case.
Same here.
The hospital keeps coming up, and ironically, Don Samuel is talking about it because he became enraged with the hospital testimony when it was going on. We heard witness after witness after witness. Now, many of the witnesses testified to the fact that Tex McIver acted very strange to his wife passing. First of all, to his wife being shot, and then to his wife passing.
Yeah.
Now, the defense will say, and what they've ultimately said, is that where is the manual on how someone should react? But then again, is it not weird, some of his behavior at the hospital?
I'm in the camp of where is the manual on how someone must behave. And you have to remember the people who are going to be deliberating this, you're going to, you sort of put yourself in the shoes when you're trying to figure out how, was it weird or not? Because where's that line? What's the litmus test for weirdness? And we've seen that in very famous trials throughout history where, a husband is accused of killing Scott Peterson comes to mind. And, he went fishing the day she went missing. And, oh, is that weird? And to me, yeah, that is weird. But to maybe be in a sort of a state of shock when your wife is not only dying, but you're responsible. You might not have meant to do it, but you're still responsible. I can't imagine what that would feel like.
Jonna, we're seeing the video right there. Maybe we could replay it again if we have the opportunity. I want to show something that's an important part when we try to understand the behavior of Tex McIver. So he said he was holding his wife's hand. He was comforting her. Well, that's not true. I mean, look at that. He's about to pick up her leg, not holding her hand. Why would he make a detail about that up? And again, the jury studied that. They saw it multiple times looking at his behavior. I mean, if you really want, you have video proof right there of right when she arrives at the hospital. It's hard to judge a lot, but you can tell he's not holding her hand. So why make that up?
So maybe in his mind at some point he held her hand before. I mean, look, if you're on a stretcher with a bullet hole in your back, he's probably in the way if he's holding her hand. I mean, they're trying to get her into the hospital.
But then why not say that? Say, I was holding her leg. They told me to hold her leg. Elevate it. Why, if you're trying to show you're a more compassionate husband when you have multiple witnesses and video proof showing it might not be as compassionate as you want it to look?
I will not doubt for a second that at some point before the chaos ensued, he probably held her hand. And in his mind, that's what he remembers. Not when you're wheeling your wife in on a gurney when she's about to die and you have the paramedics and everybody surrounding you. And look, he's just trying to help. If he wanted her dead, why didn't he sit in the car? He's there, hands-on, trying to get her in that hospital.
Well, the defense did a great job of really poking holes in the prosecution's case about also these red herrings. And one of the other things that they mentioned was at the hospital, nurses were inconsistent. First of all, he really pointed out that some of them were biased. They already thought that Tex McIver was guilty. And then one of the nurses said they heard Tex McIver say he was cleaning his gun in a sink when it went off. Only witness to testify to that. And they had to recall another witness, another nurse, one of the nurses that was actually carrying Diane McIver through, who said, I didn't hear that. I was with them from the moment they got into the moment she was brought in. I didn't hear him say that. Yeah. It really attacks the credibility of the hospital, doesn't it?
Well, it does, and it's going to go to the weight of that evidence because the jury's going to have to measure, are we going to discount what one witness said because nobody else heard it? And they're allowed to do that. They can absolutely do that. And they can make judgment calls on credibility, and if they think somebody intentionally testified falsely for whatever reason, they don't have to listen to a word that came out of that witness's mouth.
Again, the red herrings brought up by Don Simo. What did you think about the fact of the cremation and taking so long to get that settled with her remains? Is that a sign? Is that consciousness of guilt?
The prosecution wants the jury to think so. I don't really think that it amounts to much. I mean, there are steps that need to be followed, and I know there was wasn't there some issue, remind me, where he either waited too long to go pick up the remains? Right,
yeah. And then they had a friend came in and was like, I'll take care of it. I'll pay for all of this. Again.
And it wasn't that expensive.
Nobody in this case, and you could say prosecution, defense of it says that Tex McIver did smart things. He did a lot of stupid stuff or very guilty stuff. But the defense has been quick to say he's not a perfect guy. And he made a lot of stupid mistakes. But is it really just being so stupid? The guy's a lawyer, pretty successful. Shouldn't he know better than to do this?
I mean, but think about the nature of the, quote, stupid mistakes. And again, fortunately, we weren't in his shoes where we didn't lose a spouse. And I don't know if at that point he was charged with anything yet, but he still was responsible for her death. So what is the rule on when you're supposed to pick up your wife's or your husband's remains if your spouse dies and you're responsible. And again, so I don't think when you're trying to put together pieces of a puzzle to sway a jury to find that the defendant is guilty, I guess this could go into the let's throw every little thing up. Let's throw everything in but the kitchen sink. Let's give them all that to chew on, and then they can decide. I don't think it's not going to sway them, in my opinion, that he took too long to pick up the ashes.
Well, later we are going to play the prosecution's closing argument, and that was the last thing that the jury heard, the last arguments from either side. So they're going to have to determine for themselves which resonated for them, which arguments resonated for them. Now, we know Don Samuel provided a closing argument as well as Bruce Harvey. We're going to play some of that for you as well. Before we go back to Don Samuel's his closing argument, question for you, Jonna. Do you think it was a mistake for Tex McIver not to testify?
I love that question, because we talked before the end of this case as to whether or not he was going to.
Right.
And you usually only put your client on the stand if you absolutely have to, even though jurors love to hear from defendants. It doesn't always help the defendant. But in this case, I thought it would have been beneficial to him if he could have got up there and sadly said, honestly, I did not mean to do this. I didn't want to kill my wife. There was nothing wrong with our relationship. Financially, we were fine. That testimony didn't mean anything. It might have solidified it for the jury. They could still get to the same conclusion, but I think they wanted to hear from him that he's not some financially motivated monster. I don't think it's going to be the be-all, end-all.
All right. Well, we'll have to see. Now, again, we are in verdict watch on the Tex McIver case. I do want to let our viewers know at the top of the hour, at the top of the show, I should say, we mentioned that we will hopefully be covering 2 other cases here on the network, but maybe even Law&Crime.com. One is the Brian Hyde case, this horrific triple murder case out of Florida, as well as the David Copperfield civil case, where David Copperfield and the MGM Grand are being sued by a audience member who participated in a trick and was injured. So we're going to cover both of those cases. As soon as we have an update in either one, we'll make sure to let you know. But in the meantime, our focus is the Tex McIver case. I want to continue playing for you the closing argument by Don Samuel. Take a look. All right, that was the conclusion of Don Samuel delivering his closing argument for the defense there. Now, we are going to play for you in a little bit the closing argument from Bruce Harvey. That's right, both defense attorneys presented closing arguments. Something unique, you don't always see that, and we'll talk about that in a little bit. Again, we're keeping a very careful eye on the courtroom to determine. We're looking to see what the jury is doing. They're deliberating right now. As soon as we have a verdict, we'll make sure to come live with you. We do not want to miss anything here in the Tex McIver case. So let's talk a little bit again with Jonna Spilbor, our Law&Crime trial analyst. That was the conclusion of Don Samuel's closing argument. A lot to dissect there. So let's break it down a little bit. Really got into the jewelry and the fact that Tex sold the jewelry, sold the furs. Now, on one side, you could say, well, what kind of husband sells all of the wife's stuff after not only she dies, after me shooting and killing her? The other side of it is he needed to do that for money. How do you think it goes?
You know, I agree. That was a very real moment. There were several real moments in the closing argument there, but he basically said to the jury, we got to get paid. He was charged in her murder. He had several attorneys. He needed to pay us. We like getting paid. He sold the jewelry to do that. And then he tried to explain the whole, what you might interpret as a lack of sentiment. That's not it at all. Some people, when they lose a spouse, they have to move out of their home entirely because they can't stand it there. It just feels so sad. And again, that goes into the how are you supposed to act when you lose a loved one? And fortunately, most of us, if we lose a loved one, we're not also charged with that person's murder.
But he's selling all the items and he's getting money, right? And so the idea for a financial gain seems to fall into the prosecution's case. But then again, how much of that money is going to him and how much of it is going to expenses that he needs to take care of because his wife died?
And again, I mean, which is the point. That's the inference that the jury can make. Look, everybody needs money. And especially in his case, he had an expense that most of us don't have when we lose somebody because most of us aren't charged with murder. It's a very expensive endeavor. And I think what the defense attorney does here is he just makes this real and human. Ladies and gentlemen of the jury, he needed the money. We're sitting here. He needed the money. It doesn't mean that he absolutely killed her. And when you take that in context with the entire portion of his closing argument, it all just makes sense that he's not this, and he points this out, The prosecution was out to dehumanize Tex McIver, make the jury not like this man so they have an easier time of coming to a guilty verdict. And the defense attorney is pulling the rug out from that argument, saying, this is just how it was, ladies and gentlemen. Nothing nefarious, nothing to see here.
But is there something to see here? That becomes the question.
Devil's advocate.
And that really is the question. Is there something to see here? Because the prosecution, we keep faulting them for putting on a case where they seem to be getting a lot of different things. But at the end of the day, the main fact that you can't argue is you have the shooter and you have the victim. And when you show her picture, which, again, Clint Rucker will do later on when we'll show you the closing arguments by the state, the jury remembers that. And they feel that, doesn't a jury feel that they owe some justice to the victim?
I think most often they do, which would explain why, I don't know if Tex McIver is going to get a complete pass here. But there is one really important distinction that I want to bring up. Oftentimes when you're representing a defendant and you get to the closing argument portion of the program, we use that as an opportunity to make excuses for the behavior that came out during the course of the trial. Making excuses is far and away different than providing explanations. And if I had to sum up this closing argument in a word, it would be, the defense here is not making excuses for Tex McIver's behavior. They are providing explanations which are completely plausible and seem to make sense. And that sometimes can be a pivotal thing for a jury.
I'm glad you talked about that, about making sense of certain facts. So let's talk about some of the facts here. The Black Lives Matter movement, that statement that he wanted to make, then retracted, how do you think that matters in the overall scheme of the case? Because again, he made a statement that he didn't tell police. Tex McIver said that there were Black Lives Matter people, and that's one of the reasons that he took the gun out. Oh, that was the reason he took the gun out. But he told that to his PR guy. He didn't tell the police that. Right. Now, is that so wrong that you're telling your PR guy maybe to, again, this is for a media purpose. You're presenting an image when you told the police something else.
And the defense attorney brings that up too. And the defense attorney says, look, this is really irrelevant, and I want to agree with that. What does that information do, whether he told the police or he told his PR? So that's supposed to put in context why he decided to take the gun out of the glove compartment to begin with, which actually is something that's beneficial to Tex. On the other hand, it could also make the jury think that he's a racist and we should not like him. So that's one of those facts where I think they both have to do a dance. Which way is the jury going to look at it?
And Don Samuel said that. He goes, what does it matter? You want to say he's racially insensitive? You want to say he's an idiot? Sure, say all that. But at the end of the day, if he was scared of people, and it's his interpretation, if he was scared of people, that is the reason. But let's move a little bit back when we talk about the statement that he made to Mr. Dickerson, who was this crisis management consultant, and said, hey, look, if you get the charges dropped or have the DA drop them or reduce the charges, there's a bonus for you and you can share it. Now, Dickerson interpreted that as you can share that money with the DA. Now, Tex McIver wasn't charged with a bribery charge. There was no bribery count, or attempted bribery or anything like that.
Right.
So again, Dickerson felt that meant share it with the DA, but Tex never explicitly said share it with the DA. Again, why does this matter, and why should we care about it?
It matters to the prosecution because, again, they're trying to paint a picture that Tex McIver is a bad dude, and that would go along with that theory. However, on the other side of the fence, you can't really get inside some other witness's head and what exactly Tex McIver meant when he said, and you can share it. It's not, again, it's not a smoking gun. It's just another tiny piece in a puzzle that could be interpreted in a couple of ways. So who does it help and who does it hurt? Or does it just fall flat and doesn't do either? And I'm going with, door number 3 on that one.
Well, that might be the case. And the idea is really, what did the prosecution present? And what can they take away from it? And I think the strongest aspect, and you tell me, what do you think the strongest aspect of the prosecution's case, besides the very fact that we know who the shooter is?
Right. Wow. All right. I love that question. And again, I'm a little biased because having followed this entire trial, I really think the prosecution did not prove its burden that this was an intentional killing. I think all of the financial information really is more confusing than it is probative or beneficial. Gosh, I really can't say.
Look how you're struggling, and that's what the jurors are going to do. They're going to be struggling.
And if they struggle, that's going to be great for the Tex McIver camp, because they're not going to be able to come to a guilty verdict on the most serious charge if they're struggling with what did the prosecution prove to me in this case. They're not going to be able to get there.
To play devil's advocate, here's maybe what it is.
Okay,
he's the shooter.
Tell me.
He was inconsistent with his statements. He tried to...
Wait, can I stop you? What does that prove to you? As a juror, what does his inconsistency prove to you?
You could say that he was trying to hide something because he knew that he was trying
to hide his motive?
Yes.
Because we know that he shot her, but motive isn't an element of murder.
But it helps tell a story, and that's really what sells us at the end of the day, right?
Okay.
So you could say, okay, he tried to cover it up. He knew that he wanted to kill his wife. Maybe at that very second, I can't stand her anymore. I'm going to fire this gun, and I'm going to shoot her. Boom. Okay. You know what? Oh, shoot, I shot her. I didn't really, okay. Now I got to cover this up. I'm going to call my lawyer. I'm going to be inconsistent. He's inconsistent with his statements, the stories that he tells, tries to hire a PR guy, tries to hire a crisis consultant management, trying to cover up the story, try to make him look the best light. Start selling off all of her jewelry. Also, let's not forget the fact that he had a cash infusion when she died. He had, I think, $1.2 million that came in. Now, how much of that went to him, how much that had to go to the estate, we'll talk about that another time. But okay, now she's dead. He's living his life. He's getting this money. He's asking about Social Security checks, asking about her 401k. Immediately right after, that's what he's concerned about. Money, 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 money. Now, again, that would be the prosecution's probably best argument. Oh, and you could throw in a little bit of this, like, I was interested in Janie Calhoun. I was interested in the masseuse. I was interested in this person and that person. Danny Joe's shirt was untucked. You see what I'm saying? These are the arguments, but do they really stick? I don't know.
I think they could actually backfire. I think other than the financial argument, because they went through great pains to try to show who owed who what and their expert testimony and all that, so set that aside for a minute. I think the other little stuff, that he was a racist, that he might have been interested in somebody else, that he got a massage, that could backfire because a jury could say to itself, well, why is he going there? If we're so strong on this is why he shot her, because he was financially motivated and so he wanted to kill her and he definitely killed her because of that. What's all this?
Yeah.
Maybe the prosecution's case isn't as strong as they want us to believe. And if you anger the juror, if you make the jury feel stupid, you're in trouble as the lawyer on either side.
Well, again, as I always say, we'll have to see what happens. And what I want to play for you right now, again, I'm looking at the courtroom feed. Not much is happening. We're waiting for the jury to come back with a verdict. Could be today, could be tomorrow, could be on Friday, could be next week. We'll have to see. What I want to play for you right now is that was Don Samuel delivering one part of the closing argument for the defense. Here's Bruce Harvey delivering the second part. And even though there is some overlap, Bruce Harvey really, really demonstrates a key point. I'm going to preview it for you right now. When the expert got on the stand and misfired the weapon, plays that video for the jury, and that is just unbelievable to watch. Here we go, ladies and gentlemen. This is, again, Bruce Harvey. Some overlap there between Bruce Harvey and Don Samuel about their closing arguments, but there are some new points that Bruce Harvey is mentioning. We're going to talk about that in a minute. Again, we're covering the Claude Tex McIver case out of Atlanta, Georgia, a prominent attorney who's on trial for murdering his wife, Diane McIver, by shooting her from the backseat of a moving car. The defense is saying that it was all an accident. We're in verdict watch right now. The jury is deliberating. As soon as we have an update, we'll make sure to let you know. I'm here with Law&Crime trial analyst Jonna Spilbor. So what he's saying, that Don Samuel talked about, but now really getting into the meat of it, and I love this. I think this is the most important part about the whole case. How was the gun position? Was it upright? No. Based upon the analysis, it was sideways, on his lap, somewhere in between the front of the knee, by the knee, up here by the thigh. And based upon the positioning, he was just like this, sitting back with the gun, and it fired. Now, if somebody wanted to shoot and kill their wife, why would you do it in that manner? A, and B, it contradicts what the prosecution said in their opening argument, which you saw when she goes, this is how he shot her, straight, directly, point blank. We know the gun had to have been at least 6 inches away. It wasn't pointed up against the seat. There's so much to take from that.
And it is a pivotal point. And I love the fact, and this is also unusual, he put a picture of the prosecutor misholding the gun, basically, for the jurors to see. And if you're a juror who's been paying attention, I'm sure they all have, you're saying to yourself, wow, this is what they tried to sell me from the word go, because this was in their opening statement. So, you know, if they had it wrong right from the beginning, they led us down a path that is just simply incorrect. And I love this portion of the closing argument because it really is where the rubber meets the road. First, you got these two defense attorneys complimenting each other.
Yes.
You had the first, you know, easy going, I'm just going to talk to you like we're friends, and now you bring in the defense attorney number 2, and he says, I'm going to explain to you how this had to have been an accident, basically. And I like that sort of double team there. And it makes, I mean, again, this is a case about common sense in large part because he didn't put the gun up against the seat and shoot her. And if you're intentionally trying to kill somebody, I don't really think you're just sort of sneaking around with it on your lap and then all of a sudden you just don't do that.
Unless you're a criminal mastermind and you think that that's the way to do it and nobody will suspect that it's a murder. But
which they're saying.
But what I love Don Samuel pointed out earlier when he was delivering his closing argument was, let's say she survived. Let's say she survived. Then you're not only a suspect in her attempted murder, you have to take care of her. Medical bills. She no longer can work. You're going to have to figure out how to take care of her if this is really a money situation. And if you wanted somebody dead, you're not sure she's going to be killed.
Yeah, that's true, right? That's the takeaway there. And I don't really like that point. I mean, I guess it sort of makes sense in a roundabout way that if you're intending to kill somebody, you're going to do it in such a way that you're not going to make a mistake. You're not going to mess up. But clearly, I think, again, everything about this shooting, from the physicality of it to the lack of motive, despite what the prosecution says, and even the stuff afterward, but not as much, lends itself that this is an accident and nothing, maybe reckless, but certainly not an intentional murder.
You know, we're talking about right now what's probably going in the minds of the jury as they deliberate all these different questions. And I think, Jonna, we have a pretty good jury with us, and obviously we don't know who they are.
Right.
But we know that 284 questions were asked by them from all these witnesses. That's a lot of questions, let alone having a jury be able to ask questions during the course of a trial. That doesn't happen in every courtroom.
No.
What do you take from the fact that they really asked poignant questions, a lot of questions? What can that glean from there in terms of trying to understand their deliberations?
On the one hand, I like a lot of questions because it really it bodes well for the fact that they're paying attention, right? They're really paying attention. They're not sleeping through this testimony. And sometimes testimony in any case can be dry, but when your client's on trial for murder, you want the jurors paying attention at all times and getting it. And the fact that they're asking some additional questions means, all right, there's something that they didn't understand and they want to understand it. That's a good thing. On the other hand, it depends. You know, you could have jurors asking questions because they want to be the prosecutor or they want to be the defense attorney, and so they're asking questions just because they want to kind of get more immersed in the action, and that's a little bit of a different horse of a different color. But I think these jurors are asking the good questions.
There's nothing we could take from that in the sense that if they ask certain questions or even what they requested here. Now, again, just to let our viewers know about what is happening, they have requested 2 things from yesterday when they started their deliberations. They asked for 11 more copies of jury instructions, and they also asked to have the gun unlocked so that they could pull the trigger. Again, based upon the questions that they asked, what they're asking for now, anything we could glean from that? Anything we can try to understand?
You know, I'm fine with them each wanting a copy of the jury instructions because what I imagine is happening there is they're sitting around their deliberation table in their deliberation room, and you've got a 4-person, and perhaps they are talking about a piece of evidence, and now they're going to flip through to the proper jury instruction and they're going to discuss that. Maybe that's what's going on.
Or maybe it's, you know what, we know it's not murder. Guys, everybody, we know this is a murder, but is it involuntary manslaughter or is it an accident?
Right, and then let's take a look at that jury instruction and let's analyze the evidence and what we know about that. So that could be a good thing. I'm really not happy with the fact that they want to pull the trigger on the gun, only because it would be all right by me if we had testimony that said this is the exact amount of pressure it took to pull the trigger. If that were the case and they wanted to just see for themselves, I'd be all right with it. But since we don't know, you could easily now have half the jury saying, oh, this is a very easy trigger pull. I could see how he accidentally did it or was startled and did it. And then the other half is going to say, well, but if I pull it like this, it takes more pressure And it couldn't have happened the way the defense attorney said it.
How does it also work in terms of, let's say the jurors are disagreeing about a point. Some jurors are saying, well, no, they said definitively it was 12 pounds of pressure. And then another juror goes, that's not true. We don't know definitively. And then someone says, oh, I knew it was double action. No, somebody says, no, we're not sure what it is. If there's confusion, how do they get that resolved?
They could ask for a readback of that particular testimony.
They could.
They could, and see if that's going to be helpful. Or before they even get there, I mean, and the judge doesn't always have to give them the readback. Before they get there, you could have, I mean, listen, these people have been with each other. It's like a job. They have been with each other for several weeks.
Yes.
So you might have some strong personalities and less strong personalities. And the strong personalities might say, this is how I remember it. The 6 of us remember it this way, and try to persuade the other jurors to come around.
Well, hopefully they're giving a very thorough and deliberate debate on these questions.
What hour are we up to right now?
Right now for them, they might be in their 3.5-hour mark, maybe even, and so again.
For today plus yesterday?
So today plus yesterday, we're going to continue to hold it and see what happens. Why, you think that that tells you a certain thing?
I think the longer it goes, the better it is for Tex McIver, except that I don't think he's going to get a totally innocent across the board, or not guilty across the board.
Well, we'll have to see. We'll have to see, Jonna. All right, everybody. So as we wait for a verdict, we wait to see what happens in this case, I want to continue playing for you the closing argument by Bruce Harvey.
Remember him demonstrating the weapon and pulling the trigger when he testified right here.
If the gun is in single action, so with a hammer or cocked, it's primed, it's ready to be fired. The only way that the gun will fire is if the trigger is pulled and then held to the rear long enough for the hammer to fall. So if you were to pull the trigger, but then release the trigger, and I'll put my finger here so that I could feel it if it went through, it doesn't touch. Because you notice the trigger
I love that. I just love that so much. So that is so great. The own gun expert misfired the weapon. An unintentional discharge. So everybody, that's what we're doing here. We are covering the Claude Tex McIver case out of Atlanta. We are on verdict watch. We are waiting for the jury to come back with that verdict. Could be today, could be tomorrow, could be later on in the week. We'll have to see. I'm keeping a careful eye on the courtroom. Let's again bring in Law and Crime trial analyst Jonna Spilbor. I love that.
Yeah.
You have the expert. I mean, that couldn't have played better for the defense.
No. That's how they should end their closing argument, with that image of the state's gun expert misfiring the gun, because that really is the crux of this issue. The whole point is this was an accident. And the defense attorney points out, because my whole mantra is triggers don't get pulled unless your finger's on it. And he said your finger can be on the trigger, but you can still unintentionally pull it. Yes, I agree. And if the jury does, they're with him on that.
Jonna, just break it down for our audience as well. When we talk about doubt, we're talking about reasonable doubt. So explain to us, that's a reasonable doubt. Not saying, in other words, a gun can't be misfired. It's always possible. But just because a gun, in any case, could misfire or be an unintentional discharge doesn't mean that it's always can get someone off the hook. It has to be a reasonable doubt.
Right.
So, how does that reasonable doubt work in this case?
So the reasonable doubt in this case is going to involve, excuse me, the whole pie. Like, in other words, the jury doesn't have to sit there and say, okay, well, I believe that he intended to pull the trigger because he was sitting in the back seat and it was very cramped, and the only way you can discharge a gun is if you intentionally pull the trigger. No, I think the reasonable doubt is going to involve, did the state prove its financial motive? They're going to analyze all of that evidence, and they're either going to say, well, I don't really think the financial motive was there. Okay, so let's move on. Did they not get along with each other? Was the defendant, pardon me, motivated because he didn't like his wife? Well, I mean, they have evidence that he came into her office red-faced, but that doesn't really give me, beyond a reasonable doubt evidence. I mean,
Right.
I have doubt about why his face was red. All right, well, was there some other reason that he would want to intentionally kill his wife while in the back seat of a car with her best friend behind the wheel as a witness? Well, I have doubt as to why he would intentionally do that. So when you take all of the big pieces of this pie and you put them together, the only conclusion I see them coming to on the murder charge is that they cannot get there beyond a reasonable doubt.
And that really does become the question, doesn't it?
It does. That is the question.
The $1,000,000 question.
Yeah, especially for Tex McIver. This 75-year-old man's been sitting behind bars for probably much longer than he ever wanted to sit behind bars.
We had a discussion yesterday. Because of his age, he needs to get off scot-free, because any more time in prison, who knows how much time he has left, right? I mean, he's not a 30-year-old guy.
Well, you know, technically, I guess he's exceeded the average life expectancy if it's still 74. But depending on if he gets convicted of the lowest charge, he might have, I have to look up in Georgia what his exposure is on that, because he should be getting credit for all the time he's sitting there. Perhaps he would be able to walk out if he got the least amount of jail time attached to whatever he is convicted of, if he's convicted of anything.
Now, Jonna, I know our time together is coming to an end. I'm going to be signing off. You'll be signing off. What are your final thoughts as the jury goes into continues their deliberation today?
I truly think, without criticizing the prosecution in any way and their ability to lawyer, because I think there were great lawyers on both sides, the facts are not there for the prosecution in terms of why this man would kill his wife. And the facts are very supportive of this being an accident, a tragic accident, maybe a little reckless, a stupid accident, but they just were not able to prove to me that this was an intentional act on the part of Tex McIver, and I feel strongly the jury's going to come back, at least with that. The rest of it, not so sure, but for the intentional murder, I don't see it happening.
Jonna Spilbor, thank you so much for joining us.
Always a pleasure.
It was great having you on. All right, everybody. I will be signing off. Aaron Keller will be signing on. Now, speaking of Aaron Keller, he wrote some terrific articles about this case, particularly about the problems in the prosecution's case in theory. You can go to law&crime.com to read all up about it. It's really interesting, interesting breakdown about this case. Also, if you go to our Twitter page for Law and Crime, there is a poll out there. We're asking you guys, what do you think will happen? What will the jury come back with? Guilty, not guilty? Will he be guilty of murder, involuntary manslaughter? So go on there. Send in your vote. We'll tally it up. We'll present it here on Law and Crime. We want to see how you're voting. It might give an indication about what the jury's thinking about. All right, everybody. Again, here is Bruce Harvey's closing argument from yesterday.